Yeah, good morning, everyone. Before we start with today's session, I would like to inform you that this webinar is being recorded. So please turn off your camera in case you don't want it to be featured. It is my pleasure to welcome you all to the premiere of Mobile Heights speaker series with focus on intellectual property. This event is organized by Mobile Heights in collaboration with our members, Zacco, Høiberg, Clarkson and Brann. All of them recognize IP law firms in Sweden and in Europe who will be sharing their knowledge and best practices on intellectual property topics. Through these 1 hour sessions, we aim to share knowledge through short but powerful talks. And this is our way to support our mission of promoting innovation and growth in the digital world. Today, with a very interesting topic, identifying intellectual property in digital business. Zacco, one of the largest full-service IP consultancy firms in Europe, will give us a 360 perspective on how to obtain IP rights and what you should consider when securing your assets. But before giving the floor to our speakers, I would like to give some information about the technical details for today's session. So as I said, this webinar is being recorded. Please turn off your camera if you don't want to be featured. You could find this presentation afterwards in our Mobile Heights YouTube channel. You will also find this presentation in our webpage. We also recommend you to add your name and company's name in the Zoom alias. You can find information on how to do that on this chat. And we also encourage you to use the chat if you would like to ask some questions. We will have 5 minutes after each presentation to respond to your questions. And we will have 15 minutes for an open discussion at the end of the presentations. So with that information, I would like to welcome Svedin, Mobile Heights CEO, who is going to explain very shortly about our aim with Mobile Heights Speaker Series. Ola.
Thank you, Carolina. So, and good morning to all of you. So Mobile Heights, we are all about helping the community, the member community. And one of the things we do is we are constantly adding new services to the community, what we can help the community with. And therefore, I'm really, really proud that we are able to kick off today the speaker series concept. And we saw a need actually to dive deeper into IP, into intellectual property, to help the companies in the community to understand more about the topic. So I'm super excited about this and what Zacco can share with us today. So back to you, Carolina.
Thank you so much, Ula. We are excited today for this launching of Mobile Heights Speaker Series. Now I welcome our speakers, Hampus, Adlerton, and Maria Beijer, both attorneys at law and senior partners at Zacco. We will start with Hampus. He has many years of experience working with innovation and product brand development processes with identification and clearance of key intellectual property and how to protect it through contracts or by registration. And today, Hampus will be talking about a 360 perspective on the framework of intellectual assets. Why, what, when, and how. Hampus, the floor is yours.
Thank you very much, Carolina. I will start sharing my screen here. And thank you very much for the opportunity to be here and present the most interesting thing in the world, IP. This is the core business of our company, and it's something that I've been working with for almost 25 years. And what I would like to share with you for these first 15 minutes, it is a 360 perspective on IP and how you should go about to do things right. I know that this invitation has been sent to quite many people, and I think that we may have different perspectives on IP. We may have different skill levels and experiences. So what we would like to start with now is to give you an introduction. So we start with an introduction on what IP is. And then that will take about 15 minutes. And then on the second part will be an identification of the intellectual property. And this introduction, the main purpose is to have a common framework for entering the second 15 minutes. So what is intellectual property really? Well, to make it very simple and not going into any details, it is a legal monopoly granted to an individual or a company. And this could be for something creative, if you paint a painting, if you write a book, or if you write a code for a software. It could also be for a goodwill. If you invest a lot of money into your marketing, you build a strong brand, you need some kind of protection for that investment. And these are legal monopolies. So they are awarded to the creator or the company that creates these works by law. There are also other ways to create an exclusive right in something. But the traditional intellectual property, they are awarded through a legal monopoly in law. And what you get when you have intellectual property is that you get an exclusive right. And this exclusive right gives you the right to prohibit others from using your intellectual property. If you get into an intellectual property protection, it does not mean that you are automatically allowed to use what you have invented. It's not a positive right. It is a negative right. It's a right for you to exclude others from using it. And this is something that is important to know, because if you get an IP right and think that this means that you are free to use it, it is not necessarily correct. So why should a company strive for intellectual property? Well, it is because it presents a lot of values. And I have listed a couple of these values. And the ones that I think is most easiest to remember is that if you create something special, you will have a unique offer. And if you have IP protection for that unique offer, it will be truly unique because you will be able to exclude competition. And if you're able to exclude competition, that means that you could actually charge more for it. And that would improve your margins. And this was also the traditional approach to IP. I want to protect this. This is mine, my precious, and increase my margins. But then in the beginning of the about 2000, 2001, there was a book launched called Open Innovation. And suddenly everybody started to talk a lot about collaboration. And now the value of having an IP is also to have a very strong collaboration focus, because it's difficult in a complex world to create something entirely on your own. So having an IP could actually create a value for you when you enter strategic alliances or if you enter some kind of partnership. So if there are values, there are also risks. And if you do not protect your IP, or if you do not secure that you have a freedom to operate with your product, you will face some risks. And one of the risks is that you will get an injunction if you infringe someone else's IP. So if you invest a lot of money and you create a brand manual and you want to launch this trademark on the market, and but you never protect it and you never check if it's available, then you will have you may have problems with using that trademark, and then your investment is lost. And the same goes if you have created a technical invention and there's someone else having this patent. There is a risk that you will be prevented from using that invention. And the risk of not being able to use what you have created, it is, I mean, the costs you have invested, that's a substantial loss. And in a worst case scenario, you could also be forced to pay damages. And one important thing with the risk is also that if you don't have any IP rights, you can't prevent anyone else from using the same thing that you have created. And that would also affect your value as a company. Because if you have created something fantastic, but everyone is free to use it, it is a bit more difficult to motivate a high value of the company because you are not unique. So to simply summarize why you should think about IP in your product development, whether it's a digital business idea or any business idea at all, it is two basic things. The first one, it's relating to risk. You need to secure that you have a freedom to operate, so you don't end up in an infringement situation. So that's the first thing. And the second thing is that you really need to know what's it all about? What is special with your solution? Is this something I can get exclusivity? Is this something that I can add to my company value through IP protection? And if it is, you should pursue that path. Sometimes when we meet our clients and customers, they have great plans. We want to conquer the world, and we want to have a patent or a trademark right all over the world. And that is, I really like that ambition, but it's a little bit more complex than that. And there are some key features of intellectual property rights and that are important to know. And one of them is that it is a territorial right, either to a specific country or a region. And since there are territorial rights, it also means that different countries and different regions will treat your IP differently. And the courts in these countries will also treat infringement situations differently. So there are no world patent trademark protection, and there are no one size fits all answers. So it's a bit complex system. And it becomes even more complex when you look upon the trends that we are facing. The times are truly changing. We have a globalization and we have a digitalization. We have data being created in a pace that we never have seen before. We have products that reach end of life cycle in a very short period of time. And the traditional IP systems are not really set to cope with this. because it takes a long time to get IP protection. And in a global world, the territoriality feature of intellectual property becomes a problem. Because if you launch an app worldwide and you need to have territorial protection, it becomes rather expensive. And in this changed world, we need to change our perspective on what really is intellectual property. And this pyramid symbolizes how you could look upon intellectual property. And I've placed it on the top of the pyramid, and it's perhaps not always the top in a company's assets, but it's the smallest part of an intellectual asset. And what IP is normally described as, you have a human resource, you have information and knowledge, and you're able to present this, to codify this information into a document as a patent application, or a trademark application, or a design application. And suddenly you create IP. So you create value and you extract that value as patent, trademark, and design. And that is the traditional approach. But in reality, intellectual property or intellectual assets, which is the word I would prefer to mention, is created already at the lower segments of the pyramid. So what we really need to talk about is intellectual assets. And it's what kind of asset is the information? What kind of asset is the human capital? And what kind of assets are the know-how? And these are more complex because they're not possible to register. It's not possible to get a document from a governmental authority saying this is yours. But still, it is absolutely necessary to be aware of this and to protect it. And the value of this can easily be illustrated. I have this slide. It is a couple of years old, but I still think it's really highlighting what the value of intellectual assets are. And we have, during the last 40 years, seen a development where the market value of companies are based primarily on intangible assets. And if you look at these figures from 2015 and you see like 87% of the company's value is intangible assets. That is not corresponding to the number of patent applications or trademark applications that company has filed. It relates to all other intangible assets as well. Otherwise, IP firms will be the most profitable firms in the world, and they're not. So with this image, I would like to leave you and just repeat. What you get is a right to exclusivity, to exclude others. That is what you get through intellectual property. And there are values and risks, which means that you cannot ignore them when you start working with intellectual property. And you need to look beyond what is possible to register. You need to look beyond the traditional patent, design, trademark application, and also assess all other factors that creates a value in your company that is not related to a machine or a manufacturing plant, but is related to the information you have, the analytics you do, the personnel. Thank you.
Yeah. Thank you so much, Hampus. It was a very interesting presentation. Now I would like to encourage the audience to use the chat to write your questions. Here, Maria and Hampus will help us to solve those questions that you have. So I welcome you to use the chat if you have questions. Otherwise, until we have some questions, I actually have a question, Hampus and Maria. When it comes to the intangible assets, I imagine that to be able to protect them, you have to first identify them. How difficult is for a company to actually know in this digital world what is worth it to protect and what can I protect as a company?
Yeah, it is a bit difficult actually, because it's a complex world out there, and we are definitely not alone as a company. We are so depending on all other companies around us. We are depending on the technology to being able to use communication technologies, Bluetooth or whatever. We are dependent on having content. We are depending on having data from various resources. And at the same time, the legislation is extending. I mean, it's not that many years ago we got the GDPR regulations, and suddenly we have had a lot of new things to respond to. Personality rights. What can I do with my customer data? And so everything is becoming more complex. So it is a tough task to identify all IP in a company. But with a systematic approach, it is possible. And that is something we will try to share the next 15 minutes.
Yeah, okay. We have another question here from Molly. How can intangible assets be protected?
Well, I will get into that in the next part of our presentation. So if we could say that.
Rasmus has another question. Could you say that IP, when recognized, need to be set up as building asset in the financial books?
What if you need to have them as an asset in the balance sheet?
Have it valued. Yeah.
Yeah, I would repeat the question. Would you say that IP, when recognized, need to be set up as building asset in the financial books? Exactly. Yeah, he's meaning that.
Yes, I think it should, and I think you are obligated to do it under accounting principles. So if you if you look at the balance sheet of many companies, you see something called intellectual property or goodwill, and it is not always separated into the different IP rights the company holds, but definitely it is something that adds to the value.
Mm-hmm. Do we have more questions here? We have 1 more minute for responding questions. Otherwise, I will give the floor to Maria, I think. So Maria will present a fictive case on digital business idea where we'll look closer to identifying intellectual property issues that may arise. Maria, among other things, works with protection, commercialization, and enforcement of intellectual property rights by trademark prosecution, drafting, negotiation agreements, as well as advising on copyrights and IP issues. Welcome, Maria.
Yes, thank you. Yes, let's go into the process of identifying these intellectual property rights and intellectual assets. First, we would like to share with you, these are examples of very known companies in the digital business who actually do not own the assets on which they make their business. I mean, they own no taxi cars or real estate or content. So these companies are indeed good examples of companies that have their value based on intangible assets. And we would like to share our view of how these could be identified, these kind of assets. Well, as a first approach, of course, it's good to know what you should look for, what could be possible to protect. So what you see in this image is the image of it's a banking app. Now, there could be a number of different assets connected to this app, which at least theoretically could be possible to take care of, to register if possible, or to keep track of. So if we start by with copyright, you might think primarily on protecting literary or artistic work, but applied to software, there could be copyright in the software code, for example. There could be copyright to text and images as shown in this app, or to marketing material. Or if the app collects data, there could be copyrights to the database. In most countries, copyright is not possible to register. The rights arise as it is created. But we do have some countries where it's possible to register. For example, we have the US, we have China and India. We can actually have a document proving your registered right. So if we move to patent, patent protects a technical solution. So there could be worth to look into. There could be patentable solutions or methods in the software. Patent is possible to register, and just as Hampus mentioned, it is a negative right. It gives you the right to exclude your competitors, but it doesn't necessarily give you the right to use your invention. If we move over to trade secrets, then we are more on the intellectual asset side, because trade secrets, that is the crucial information in a company which provides a competitive edge. And the value of trade secret typically lies in the fact that it is not commonly known. So to keep its value, trade secrets needs to be kept secret. Example of trade secrets, well, that could be all different kinds of data or know-how, technical knowledge in the company, manufacturing processes. This information is not possible to put into a registration, so it needs to be kept secret. Then, of course, there could be trademark connected to this app. A trademark protects the origin of a product or a service. It could be a word, it could be a logo, and that is a figurative element on its own or together with a word. It could be a tagline, like a slogan, or it could be 3D marks, and etc. And when you have your trademark registered, then you can block the competitors from using your exact trademark or a similar trademark for the goods or services that you have registered, or similar goods and services. And the digital side of the trademark is the digital brand. There could be a domain name connected to this software app that could be worth to register, or for example, social media accounts. And the final box is design rights. Design rights is all about appearance. It protects the appearance of a product or applied to a software, it could be the graphical user interface, what it looks like when you're using the app, or icons that are shown in the app. So now that you know what to look for, the next step is how to gain access to these assets. We have defined the situations into 3 specific categories. And the first is that you actually develop it yourself. That is one way of getting ownership, getting access to your assets. When you do that, it opens up for a need of a number of different kinds of agreements. First, you need to maybe register your assets if it's possible. And you will need, for example, NDAs, consultancy agreements, development agreements, depending on the situation. Another situation is that you could purchase the asset. Then you need to record your ownership, and you would also have the need of different kinds of agreements. It should be noted, though, that a company doesn't need to own it itself, develop it itself, or purchases to be able to gain value from assets. Because a third alternative is to get access to the assets through a license, to become a licensee. Also here, they have a need of a recorded process and different kinds of agreements. So as you can see in these examples, there could be a lot of different stakeholders. And there is a lot of IP that needs to be considered when interacting with these stakeholders. So let's show this in a more practical example, the relationship with different stakeholders. Let's say we have a company, it's called Big Dreams Company, and they are about to develop an app. To do that, they have employees, but they also need external developer to help them. And they need some content, so they have a content provider. With each and every part, there is an agreement situation, contractual situation that needs to be highlighted. And there are IP issues that needs to be considered in all of these situations. Also, in terms of users, there is a need for contractual agreements. And if you use the cloud to store information, then you have a cloud service provider, and there's another stakeholder to consider. All of these relationships contain IP, and it's really important for a company to identify and to take control of that IP. For example, in relation to a content provider or a developer, who owns the assets that comes out of the collaboration? Do you as a company get ownership? Do you maybe get the right to use? Do you get a license? It's really important to know what kind of collaborations you have and to take control of your assets. There's a lot of information. We will share this presentation, so I won't get through all of this. But the important thing is that a company has a lot of contractual relationships with a lot of different kinds of stakeholders, and in the actual world there are many more boxes than this, and so there are a lot of agreements, different kinds of agreements, but they all includes IP. So it's very important not to forget the IP. For example, with the cloud service provider, let's say that you have critical data, you have trade secrets stored in a cloud service, and then it is tremendously important to consider the IT and information security. because as I mentioned, trade secrets, their value lies in the secrets being not publicly known, should be kept secret. Sorry. Some key IP then to consider, a bit of a summary. We have the copyright, we have the trade secrets, we have patent, we have data or big data, as it likes to call, and trademark and domain names. These are key IP, and that needs to be considered and identified by each company. As Hampus mentioned, there is no one solution fits all. It is different for different companies. But these are the more traditional kind of rights. So it is also important to not forget this 360 perspective. I mean, as I mentioned, the cloud service agreement, it is very important to look at the IT and information security. So you know that your trade secrets are stored in a secret way. And also in these different kinds of agreements that you do highlight the IP, remember the IP, and take control of it. And not be surprised by the fact that you only have the right to use when you actually thought that you were owning the IP. So the last slide and the big question is where to start? Well, we suggest to start with an intellectual asset strategy. And that is to highlight all the relevant assets for this specific company. Make it a part of the business strategy. It should have the same goal, the same values as the overall business strategy of the company. Align the strategy across different departments within the company or different disciplines. Keep it dynamic and adapt to the strategy. Well, this was our last slide, I think.
Oh, perfect. Very interesting, Maria. Thank you so much for that. We are starting to have questions. I just want to inform you, we open 15 minutes for questions and comments. So please, if you want to ask the question yourself, you write your name on the chat so I can give you the floor. Otherwise, you can just write the question on the chat. So Rasmus from Block Zero asks, could you give some example, know how to think about this for a pure service company? It's much more difficult when there is not a concrete product being developed.
Yes, I agree. It is more complex. It tends to be easier when you have a physical product, maybe. But also with the service, I mean, to think about what kind of assets is crucial for that company. Maybe it is a collaboration with others to make it happen. Maybe it is a strong trademark.
Yeah, and I could fill in that regardless if you're a product company or if you're more of a service company, you have an offering to the market. And that offering, that is what you want to protect. And start by identifying what is your offering, what is your service offering to your clients, and how do you get paid? Because if you know that, you really have a good starting point to understand what you need to protect, or if you need to protect it.
If you have more questions, you can write it. We have another question. I think an example will be good to highlight a scenario where you may own a patent, but you can't use it.
Yeah. Well, first, I should say we're not patent attorneys, but well, it is you can patent, you could patent a smaller part of a larger amount. I'm trying to get some good example here. Because you can get a patent granted that is actually depending on another patent, which means that you could meet the requirements to register that patent, but you couldn't use it without infringing another broader patent. I know we will have colleagues following up our session with specific patent sessions, so maybe I should just leave it the details for them. But it is important to just keep in mind that it is a negative right. You have the right to block others from using your technique.
Yeah, and if we do take an example from the more connectivity part, if you want to do some kind of solution that utilizes telecommunication technology, for example, if you want to make a refrigerator that communicates with your car, why I don't know, but then you will need to have use different telecommunication technologies that probably are owned by Ericsson or some other companies, and they have already patented it. So even if you do this extra step, you may still be depending on having the right from other patent holders to use their patents. And in real life, this could be, in the case of telecommunication, is a little bit easier because there's a lot of standards, and you can get access, get a right to use these from your supplier, perhaps. But that's the theory, that someone has patented something and you have done something on top of that. Perhaps you don't even know that you did it on top of something that was already existing. But there are some underlying right that you need to clear.
Great. Now we have a very interesting question from Anders Boyd. Apart from arguments mentioned, unless I missed something, it seems investors are very much like companies having patents. Is that still a relevant argument?
Yes, I think it's a relevant argument. I mean, for example, when you make a due diligence of the company, whether you should sell it or you should bring in more money, it is definitely interesting to look into the intellectual property rights. And at least in some line of businesses, yes, patents is very, very important. So you could say that it is easier in most cases to get an investor if you have your technique protected, if you have a patent. So highly relevant.
And in the due diligence process, and it is of course a bit different if you're a small startup or if you're a bigger company, but in a due diligence process, you provide all data relating to your intellectual property and lists of patents and etc. And the law firm, they will look at these lists and they will see, yeah, you have these rights, and we can have this as an exhibit to the agreement, or we can confirm that they are registered. But what the purchasing company normally do is that they make a commercial evaluation. Is this patent relating to the business, to some income in the company? And then they can make some kind of assessments of the value. So for a more mature company, it's definitely that the list of patents are extremely important. And for a smaller startup, it is, you are selling hopes. Sometimes you want to conquer the world, and small startups can do that, like Facebook, now 2 billion subscribers of the service. But when you start small, it's perhaps not only the patent, it's a lot about the people involved in the company. But you're selling hopes, and then if you can get the position, of a patent, it really supports that thought of a hope to be big.
Mm-hmm. Great. I have another question, Hampus. At the beginning of the presentation, you explained that IP protection could take time, and nowadays it's very complex. In your experience, how long does it generally take from when you start the IP strategy until you get full protection when it comes to digital business ideas or digital business?
Well, I think that doing a strategy work and setting the goals and purpose of securing IP protection, that is a fairly fast process. Doesn't need to take more than, well, of course, depending on what kind of company you're in, but weeks to a couple of months to do an identification and have a strategy ready. And then it's the implementation of the strategy that takes a lot of time. And if your strategy means that, well, we have limited resources, and we think that the copyright protection awarded to software and combining them with the license agreement to our customers, that is good enough for us, then you're already there because you get the copyright protection without any registration. And you perhaps need to write some kind of proprietary notices and also make sure you have the license agreements with your all people, your users, and so. But on the other hand, if you decide that for us, getting a patent is much more, it is a value for our company because it gives us a broader protection than the software, the copyright protection for software do. Then it will take a long time because it takes a long time to draft the patent application, and then it can take I mean, the 3, 5, 6 years to get the patent granted. And during that period, it could be difficult to enforce a patent application. There are some sort of provisional patent protection, but there are strict requirements for actually benefiting from that provisional patent protection, and it's different in different countries. So if you, for example, go to the States, you really need to if you find an infringement and you only had a patent application, you need to write a letter very carefully to include all the relevant details to be able to rely on the patent. So
yeah, so for the business, and I imagine to maintain that strategy, you need to have some efforts with your employees, maybe educate them on how to maintain those relations with the stakeholders. So it's a strategy for the whole business. Mm-hmm.
And the employee perspective, I think, is very important for smaller companies and startups, because when you start up, you perhaps you even work for free. And if you don't even get a salary and you're making codes nighttime away from your normal work, you don't have any employment agreement at all. And without any employment agreement, who owns the code? Mm-hmm. Well, it's the individual that actually owns it because they're not formally employed. And yeah, it's a lot of things about with employment as well.
No. Do we have more questions? You can write it on the chat. Okay, we have one from Rasmus. Hur ska, this is in Swedish. Hur ska man bygga upp IA om man är ett mindre företag med K2-redovisning?
Okay. Om man tänker, okay, I was about to answer in Swedish. I will keep it in English. Well, if you consider intellectual assets in a broad perspective, I suppose the question relates to how to keep it secret, because as I mentioned, trade secrets have their value in being kept secret. And they could be kept secret, for example, by limiting the access to the information. Maybe not all in the company needs to have access to all information. And then we have this IT and information security, to have it stored in different in secure systems. For example, if you have cloud providers, cloud service providers, to make sure that they store it in a secure way. I don't know if that was answering the question.
Yeah, are we satisfied with the answer? You can the chat. And I have one more question. Sometimes you have companies that are in this question of patent or not patent, because a lot of companies believe that the IP strategy of the IP protection could be very expensive. What are the pros and cons, and when do you recommend to start doing that?
I would do it at the same time as I formulate the business idea of the company, when I do the business plan. And as any business plan, things can change underway, and so can an IP strategy. But I think it's extremely important to consider the business model. How will you earn your money? And if you have a license solution to your users, what will you license? Yeah, you will license IP or some kind of data or information. And if you haven't thought that through in the beginning, and how you should go about to have these exclusive rights, it could be too late later on. So better early than later, and realize that nothing is forever. Growing a business is about adaptation, and start with IP strategy early, be prepared to adapt it to your business needs.
And I would just like to add that specifically for patents, I mean, you have the novelty requirements. So if you are going to patent your invention, you have to do it while it is not publicly known. So it has to come early in the process. And relating to costs, if you compare the costs of the, I mean, gaining a patent protection to maybe being blocked from using, I mean, your complete company could fall apart if you're not able to actually use your technique.
Mm-hmm. Yeah. Yeah, that answered my question. Okay, so if we don't have more questions, I think we're going to close the session for today. I want to thank you both, Hampus and Maria, for this very interesting presentation. And before we say goodbye, I take the opportunity to invite you all to our next IP speaker series, which will take place on November 25th at 11 o'clock. Where Høiberg will be presenting about patenting of software, and in particular, artificial intelligence. So you cannot miss it. Thank you so much for today.
Thank you.
Thank you.